Good afternoon, everyone, and welcome to the webinar, Marijuana in the Workplace and What's New for 2021. I'm one of your hosts, Chris Santomassimo from Santomassimo Davis, Outside General Counsel Solutions. We really appreciate everybody joining us today to, in some cases, start a dialogue, in other cases, continue the dialogue about an issue that, in my opinion, is one of the most challenging issues facing employers today, probably just after COVID-19, of course. So what we're going to talk about is what's the landscape today on this really important issue and how can we manage through it. Um, what I'd like to do is also I'll let you know that joining the program today later in the presentation will be Steve McMaster from PCV Capital, who's going to introduce everyone to a really interesting technology and product called the Recover testing platform that allows saliva testing for marijuana. So we'll be able to, after we understand what the ground rules are and what the and have a discussion about some of the issues, Steve will talk to you about what is a really interesting technology that I think will enable some of us to get through these issues in a little bit more better fashion. I have to say that I think a lot of us have been preoccupied with managing through COVID-19 over the last year for sure, and I think that's taken our attention away from a lot of different issues like marijuana and how it impacts the workplace. But as we start to settle down a bit from COVID-19 and start to get back to business, considering all the legislative developments that there have been in this area, I think it's time to make sure that we're all prepared and we're understanding what's going on, both at the executive level and the legislative level, and prepare for some of the changes that are coming for sure. I think the main thing that we're going to focus on is how to get through some of the confusion that employers face, because what we'll see is some conflict between state law and federal law. We'll see differences in among the laws of different states, even the states that are contiguous with New Jersey. Our focus is going to be a lot on New Jersey today, but you'll hear some discussion about what's gone on in other states in the past and what's going on in other states, because I think certainly the national activity is going to shape what happens in New Jersey for sure. And I think that there's definitely a learning experience among the states, and I think they're looking at each other for purposes of identifying trends and probably solutions to some of these problems. I think in addition to that confusion, one of the things we're going to recognize today is that much of our concern and much of the problem that employers face comes from the fact that this change in how we approach the issue is really an entirely new paradigm. It's in conflict with the way we've managed through this issue for decades. And federal law, as you know, has outlawed marijuana for decades, since the early 1970s. And as employers, we've dealt with the issue in a different way, a much different way than we're seeing today, both as it applies to medical marijuana use among employees, as well as recreational use, which is the new wave in many places. So before we get started in the details, what I'd like to do is just talk to you briefly about the agenda for today. What I'd like to do is just introduce our firm for a moment so that you understand the context for this, because in our role as outside general counsels for companies, this is very much a forefront issue that HR professionals as well as other executives are dealing with day to day and coming to us for advice. We'll talk about this conflicting landscape that I mentioned. Square one, where are we starting from? What's the current snapshot for today? Where is marijuana still not allowed despite what's gone on at the federal and state legislative level? We'll talk about legislative developments in New Jersey, pre-employment testing, medical marijuana. We'll also cover recreational marijuana use in the course of these topics as well. And then lastly, again, talk about Steve McMaster and the Recover rapid testing platform. One thing I'd like to encourage everyone to do is have a dialogue as we go through today's program. Hopefully you know that in the Zoom platform, there's a Q&A function where you can post questions. So post those questions and we're happy to answer as many of those as we can toward the end of the program. A lot of times what you find is that a question that might come up in the middle of the program sometimes will be covered a little bit later. So let's do our best to be a little patient and we'll answer them in the best order that we can. And then I don't want this to be the last time we all talk to each other about this issue. Not only is the law developing in this area, but your workplaces are certainly evolving post-pandemic for sure, and maybe changing in response to some of the things we're talking about today. So what I'd like to invite everyone to do is continue the dialogue with us after today. And in fact, our team will reach out to each of the folks that attended to set up some time to continue that conversation. And you can feel free to reach out to us with questions as they come up after today. So just briefly about our firm, as I said, the topics that we're talking about today were really ripped from the headlines, if you will, from our day-to-day practice. So we are outside general counsel for mid-cap companies, which means that our firm becomes the virtual law department for companies that don't have their own internal legal counsel, but have needs on a daily basis to help them manage through a variety of business and legal issues that range from employment to real estate to contracts, et cetera. Many firms that aren't big enough to have their own attorneys in-house, find themselves subject to high hourly rates and, dealing with law firms only on an emergent basis. What we want to do is make the benefit of having an internal counsel more available to those smaller companies, but on a fractional basis. And we're able to offer not only a team approach to help you through your legal issues, but also we can do it on a fixed fee. So you'll know month to month what your fee is going to be and that all of your legal issues are handled for a single price. That gives you more predictability, your more ability to budget, et cetera. So because of that relationship we have with our clients in the mid-cap space, they come to us pretty frequently, especially those that are under a fixed fee, to have dialogues about these issues and really get our business input as well as our legal counsel on a variety of issues. So some of the things I'm going to talk to you about today come right out of those client relationships. So they're not only hot from a timing perspective, but these are things on the tongues of employers in New Jersey and elsewhere as they try and manage through these issues. So as I hinted at a moment ago, we've got a lot of sort of conflicting things on the landscape in front of us right now, which I think makes things a little bit more difficult to manage as an employer. You sort of start from the place that at the federal level, marijuana remains illegal. It remains illegal to possess, to transit, to sell, to handle in any way. It's a Schedule I substance on the Controlled Substances Act. People have been arrested for it and prosecuted and jailed for it for many decades. And that's the paradigm that employers have operated under for a very long time. And quite often your company policies are going to reflect the fact that pot is illegal or has been illegal at the federal level. But what we started to see about 9 years ago or so, maybe a little bit longer, is that states started to think about new ways in which to deal with marijuana, really in two categories, certainly on the medical side as well as recreational. And what we started to see with Colorado being the first one in 2012 is that states legalized the use of marijuana on a recreational basis, and many more states, 34 or 35 of them now, have made marijuana legal at the state level for medical uses. So you got a major conflict in terms of how the states are dealing with it as well as at the federal level. What's interesting about it too is that, in my opinion anyway, there are a lot of there's a lot of political overtones over this issue. So we see it in the news in different contexts. One side of the aisle has one view of it that contrasts and conflicts with the view from the other side of the aisle. It doesn't really matter which side of the aisle you're on and whether you support the idea of legalization or not for today's purposes. But you got to know, I think, that the push certainly has political overtones, the push to make it legal. But how we deal with it as employers doesn't really matter. It doesn't really matter what side of the aisle you're on, but what matters is what your business objectives are. That's what we want to help isolate is what are your objectives? What's the set of laws and the set of requirements that your business needs to operate under? And how are we going to come up with a policy and a program that makes sense for your business, given all of the requirements that we're starting to see develop? In our own backyard, it's been talked about quite a bit in the last year or more now. Right here in New Jersey, we've had medical marijuana that's been considered legal for a number of years. Now we talk about recreational marijuana, which, thanks to the referendum in the last election, it's now legal in New Jersey. Now we're not there yet, where you've got dispensaries that are sanctioned. In fact, the process to get that process underway has really just begun at this point. But all of a sudden, it's an issue, and it's not too rare that you wouldn't be in a public place and smell marijuana in the air, as I did last weekend in Atlantic City. It's happening. The fact that the referendum went through is really just kicking off a whole new way of dealing with this, and you're going to see it more and more often, even in advance of the state approving dispensaries and the whole licensing process for sure. What I also find interesting is the view, as indicated in the Gallup poll I mentioned on this slide here, that 60%, 67% of Americans favor legalization. Now, that's public opinion. It contrasts with some things we're going to see on later slides in terms of what it does in the workplace for sure. But it's kind of interesting that that's how people view marijuana on a national level. What's interesting to me too is the fact that there that when you talk about marijuana, we're talking about a substance that has virtually no standardization. It's not regulated by the FDA because it's not legal at the federal level, right? So there's no FDA oversight to determine whether it's effective to treat certain illnesses or whether there's any standardization among the products that you're going to see. So there's no quality control. Efficacy has not been proven. And it's much different from alcohol, for example, which is, a substance that has, some similarities in terms of how they affect individuals who use it. But it's a lot more difficult to manage, as we're going to talk about. So we've got a product that's being introduced into society that's got virtually no regulation except with respect to who can sell it and where and who pays taxes for it. So to me, that's a pretty major hole that needs to get filled. But for the time being, it's a hole we sort of have to live with because of this conflict among laws. And as I think about this issue about marijuana in the workplace, this is a question that sort of occurred to me recently. It's what does marijuana in the workplace and COVID-19 have in common? And it sounds like a crazy question to ask, especially given what we've dealt with COVID-19. But to me, the answer is that we're dealing with new paradigms, new points of view, new ways of managing employees, and new ways of dealing with how people function in the workplace and under what circumstances. Again, doesn't matter what side of the aisle you're on, but I think what it tells us as employers is that we need to think about things in a more flexible way and to look at the issue perhaps through a different lens than we've looked at in the past. And part of the reason that you need to do that, I think, as an employer is the question of whether you're going to be able to attract candidates to fill the positions at your company if you don't think about this in a new way. Because I know from experience, so I've got multiple clients who have a difficult time filling positions, especially in the manufacturing and distribution environments, without amending their old drug use policy or drug testing policy. I can think of one in particular that frankly was seeing failures of at least 7 out of 10 people who applied for their jobs. These are people that were otherwise qualified but couldn't pass the drug tests because they showed positive for marijuana. So again, to me, you need to think about how you're going to manage your workplace in a more flexible way. And when I sort of analogize it to COVID-19, what I'm talking about there is that the ideas about when we work and where we work in particular and how we perform our jobs really got turned upside down beginning last year with the pandemic. So it required us as employers to look at things and how do we get productivity out of people and how do we make sure that people are doing the jobs in a very different way than we did before the pandemic started. So again, flexibility is where we start. And when I try and sort of boil it down into its most important elements, it's not so much about reimagining the workplace, which apparently is a pretty popular phrase these days. I think it's more about rebalancing. I'm not advocating that we think about marijuana in one way versus another, but if you're going to manage your employers or your employees rather, and you're going to keep your business moving, it's probably time to think about things in a new flexible way. And I think also too, recognizing that there's probably some generational differences on this issue as well, that probably feeds into the paradigm that we need to think about as we, again, rebalance how we do this sort of thing. I don't know if that makes it any more palatable, quite frankly, these changes, but if you think about it as just sort of advancing and recognizing that maybe certain views in society are changing a bit, can we sort of encompass those new views and rebalance in a way that's going to allow you to get business done, do it in a safe way, but also do it in an effective way, and maybe open up the open up the doors to folks that otherwise wouldn't be eligible to work in your workplace. So square one in my mind is, where do we start from? Um, what's interesting about marijuana, and one of the many things anyway, um, is what I mentioned before, and then how do we view, users of it, and how do we deal with the impacts of people that use it? This idea of being under the influence is pretty difficult to determine under many circumstances. If somebody were under the influence of a narcotic or alcohol, a lot easier to deal with, a lot easier to recognize rather, and a lot easier to manage. Managers understand what that means. Employers can see it a lot more easily than they can for somebody who is under the influence of marijuana. So what we're going to talk about later is the need to train your employees and train your managers in particular about how to see it and how to deal with it. And that's going to focus in and probably that's going to help you focus a little bit about what your drug testing policy is going to be, and what are you going to test, who you're going to test, and how you're going to do it. Secondly, I think employers really need to adjust for medical marijuana use as well. There's been a couple of decisions out of the New Jersey Supreme Court over the last number of months. In fact, one was just last week, which give us some real guidance in this area. But putting aside all of the other pieces of those opinions, what you realize is that employers really need to adjust for medical marijuana use because it's happening more and more often. It's being prescribed quite often for a lot of different ailments that go beyond what it originally was being prescribed for when some of these opinions came out, namely for cancer. We're seeing lots of other uses for it. Again, as I said before, we don't know whether or not it's effective, and there's been no FDA studies on the issue. But at the same time, we've got licensed physicians who are prescribing it. So we got employees who are using it. We're going to have to deal with it in the workplace for sure. That plays into the code of conduct issue. Many of our companies likely have a code of conduct that's got something to say about a conviction history, whether you're going to hire people with a conviction history, people who have been arrested for drug possession. I think it's requiring us to look at this in a very different way and perhaps amend those policies to come up with more workable policies that are going to make some concessions for offenses that relate to marijuana, especially when they're in very small quantities. And we'll talk a little bit more about that in a bit. Kind of where you start from, though, is that employers generally do not need to accommodate recreational marijuana use. However, more and more exceptions are growing, and we're seeing that in the legislative activity we're going to cover a little bit later. So we really are thinking about things in two different silos: the recreational silo, and maybe the more complex one is the medical marijuana silo. So what you need to have as an employer is a policy that's going to balance all those issues, and have a written policy as well. What we're not going to talk about is specific policies, because quite frankly, I think the answer is going to be different for each employer. So what your business objectives are, what your business is, what industry you're in, and what your operation is, all of those things are going to come together to instruct us about exactly what your policy ought to look like. But we'll talk about some of the elements of it as we go and give you some food for thought. Also, too, I think one thing we need to spend more time on in general is encouraging a speak up culture at our companies. And this really feeds into the code of conduct that I mentioned on the last slide. The idea that what we want is to have people evident or aware of what's going on in their workplaces and have employees speak up when they see something that's out of line. When we talk about marijuana, what we want to do is to have a coworker speak up and report to a manager when he or she sees a coworker that may be under the influence of marijuana. Not evident to the manager, but there's something about how they're acting that's just not right. So what we want to do is encourage people to raise their hands, speak up, and hopefully avoid some accidents and injuries, but also deal with what we're seeing more and more often is that people are using it without reporting it to their employers. This I thought was some interesting information about what it does to the workplace. So the National Institute on Drug Abuse did a study. Employees who tested positive for marijuana on a pre-employment urine drug test had these things happen: 55% more accidents, 85% more injuries and 75% greater absenteeism. So you can see that these factors, I think, are in direct contrast to what is this, this groundswell of support for legalizing marijuana. What we see as employers is that it's not good for the workplace in general. So that really factors into the balancing I'm talking about. So I'm not suggesting that this is necessarily a good thing for employers, but what I mean by balancing is trying to balance this issue, the realization that we're seeing a lot more accidents and a lot more injuries and other problems related to the use of marijuana, but at the same time recognizing that it has now infiltrated the workplace and will only increase as we go. So if we're going to continue, especially in the blue collar environments, to attract candidates who can do the jobs, this is something that we probably need to be factoring in. You may decide as an employer that you can't live with, some of these changes, and that'll be part of your policy as well. But I think we need to have an open dialogue as managers to figure out what the right balance is for the particular employer. And I also think that when you talk about policies, having policies in place really give people notice about what's expected of them, but also helps you as an employer promote consistency among your workforce, so that you've got standards written down that would be applied when a certain event happens. Again, it puts people on notice, but more importantly, it gives managers a guide about how they're going to manage these issues as they go. And when you've got consistency, you've got, I think, a better and more reduced exposure when it comes to claims for discrimination, claims that you treated people in a disparate way because of some improper category. If you've got a standard on the books in your policies and everybody knows about it, you're more likely to have a more consistent approach and less claims in that area. So it's got value that goes beyond managing. It goes beyond managing through the marijuana issue. So far we spent time talking about the foundation, or the place we start from, or square one. I just want to recognize for a moment places where marijuana use among employees is still not permitted, still not allowed. So federal employees are not permitted to basically have a positive drug screen for marijuana, and they can be terminated in most cases. Federal contractors, that is contractors that are in companies that are supplying goods and services to the federal government, need to have a drug-free workplace and can't permit recreational marijuana use, and to have people with positive drug screens, subject to some of the medical marijuana things we're going to talk about later. There's the Federal Drug-Free Workplace Act. And then when you talk about Department of Transportation, that is basically truckers that are doing interstate travel, the DOT does not authorize the use of Schedule I drugs, including marijuana. So when you got workers that are in safety sensitive positions and they're subject to testing because of their commercial driver's licenses and their DOT certifications, you got to recognize that CBD use, so maybe not necessarily marijuana, but CBD products may also cause a positive result. So truckers need to be certainly careful about that. But these are places where we're not going to allow, and we can't allow recreational marijuana use. And in general, and with some accommodations that may be required because of medical use, they're generally not going to be permitted to show positive drug screens for marijuana. So what we've seen over the last couple of months is a lot of activity in Trenton, basically around the legalization of marijuana. So this the new statute, New Jersey CREMA is the acronym for it. It's the Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act. When you boil down a lot of pages of legislative activity, here are the high points of it. Employers, as I said before, can maintain a drug-free workplace. That is, they can prohibit the use and possession and being under the influence during work hours. And that's consistent with how most employers have managed this issue for decades. This is where it starts to change the playing field a little bit, is that employers can't refuse to hire, they can't terminate, they can't bar, and they can't discriminate against individuals because of recreational use of marijuana. Again, as long as you're not in one of the industries and one of the categories I talked about on the previous slide. of course, but you can't refuse to hire people and you can't terminate them just because they use marijuana outside work hours and they don't show up under the influence in the workplace. So you can't take adverse employment actions against the applicants as well. Now, here's where the exceptions come in. Federal requirements, as I said a moment ago, federal contractors, and then safety sensitive positions. And we'll talk in a moment about a bill that's trying to work its way through Trenton now, uh, which in my opinion may create more ambiguities than it helps. But in any event, we'll talk about some exemptions there. Um, and then, so testing is still permitted under this statute as long as it's reliable. And there's a physical assessment about the state of impairment. So if an employer's got a reasonable suspicion, or there's a suspicion, and you're going to test post-accident, random testing if you've got a program in place, and then pre-employment with some limitations. You can still do testing under these circumstances. But as you can see, when you talk about pre-employment testing being allowed, it may conflict with the inability to bar people because of use off hours. So we've got a lot of sort of developing topics that don't all fit together at this point, and we're doing our best to sort of manage it. But this is the current state of it, of the statute as we have it today. When we talk about an adverse employment action, by the way, it's basically all of the things I mentioned before. That is refusing to hire or employ somebody, discharge an individual from employment, requiring them to retire from employment, or discriminating against an individual in terms of compensation, conditions of work, terms of employment, or any other privileges of employment. So it's a pretty broad standard. This is the bill that Senator Sarlo has proposed in order to amend NJ CREMA. And as I said before, I think it may create more issues than it helps, quite frankly, but I want to just go over it with you real quick. So the proposed language is that no employer shall take any action to prohibit an employee using cannabis items during non-work hours, except what he's listed here, upon a determination that it's a safety sensitive position, or is at a critical infrastructure facility or construction site, and has an exceptionally high risk of potential harm to other employees or to public safety. That sounds good. That sounds like it makes sense to me. But what's troubling about it is that the bill is basically saying that the approval to designate an employee as being within that exemption is going to be subject to the Cannabis Commission and a decision by the commission upon an application by the employer. So I think what that means is that if you've got a position that you think is safety sensitive, and you want to be able to test for marijuana use within that position, you're going to have to apply to a commission. You're going to have to wait for a decision before you can actually do the testing. So I think logistically, it puts an exceptional burden on employers. It remains to be seen whether this amendment will go through and exactly how the commission is going to work. But just on its face, I think it creates probably more harm than good in terms of our ability to manage in an effective way. But we'll see. The commission only began to meet last week for the first time. So we're at the very early stages of this. I can't even predict exactly how it's going to work for employers. All I can tell you is that the way it's shaping up seems to create a lot of complexities that just make it difficult to implement the exemptions. And I'm hopeful that that Trenton will actually ease up on some of these before any of these changes are made. But again, we'll see how it goes. So as with a lot of things we're talking about, things are evolving in some cases at a snail's pace, and in some cases very quickly. So what we got to do is just make sure we're on top of it and we're monitoring the changes as we go. So let's take it to the next step, which is the decriminalization of recreational marijuana. So again, as I said at the very beginning of the presentation, what we're talking about at the federal level is that it's a Schedule I substance, that possessing it in any form and in any quantity is illegal. At the state level, what we're seeing is a relief of that issue, change of that issue. So at the state level, what we've seen is decriminalization, that essentially 6 ounces of marijuana in your possessions or 17 grams of hash is no longer a crime and won't be prosecuted. no civil consequences, no criminal consequences for having it. Basically, what this means is that under 6 ounces is considered uh, without an intent to distribute. So more than six, you've got a problem. The question I would ask too is whether or not there's going to be robust enforcement even at that level, to be honest. But we'll see how that goes. But this is how it is today. So um, what we've got is basically the what I think I've seen here is the threshold for what is a small quantity that's beyond regulation has been lifted from a very small amount up to 6 ounces of marijuana. And if it's going to, when you talk about a substance that's being bought, sold, or used under the state regulatory threshold, it's going to be considered regulated cannabis that can be transferred again at the intrastate level. And these are part of the three reform bills that Governor Murphy signed. I think it was in January, if I'm not mistaken. So this, I think, the absence of criminalization of the marijuana, and now this new attitude toward its use on a recreational basis is really what I think is creating the issues for us as employers. Let's talk about just for a minute what happens to people when they use marijuana. So this is the issue I mentioned earlier, in that being able to recognize the signs is difficult. Even with training, it's sometimes difficult. But as employers, I think where we need to start is making sure that our managers can recognize it, especially in an environment that's a manufacturing facility or a distribution facility, and in safety sensitive positions. Folks that don't have their own experience with it certainly need to be trained even more. But these are some of the things that you see: reddening eyes, dry mouth. Uh, when you talk about what you're seeing from the outside, erratic behavior, the eye condition I mentioned, loss of coordination, you see delayed reaction times, which I think probably feeds into those higher accident rates that we mentioned earlier. People just aren't able to process, they're not able to process things as quickly as they normally would. Things are distorted in many cases. So things that would normally be sort of simple tasks are not so simple anymore when you're under the influence. But again, very difficult to recognize, especially when you talk about edibles. So it's one thing to be able to smell the smell of smoke on somebody who smoked marijuana in the recent past. It's a whole different ballgame when you talk about edibles, which have in many cases the same impact on your employees as smoking marijuana. And when you talk about edibles as well, there's going to be a delay in the impact of the edible on the body, because what you know is that when you ingest something, it's going to take maybe a half an hour or so to get from the stomach into the bloodstream and have the impact, the desired impact. So even if somebody were to use an edible, say on their lunch hour, they might not actually see it until at least a half an hour later when they're in the middle of a work task. So again, there's no temporal connection between the use of it in many cases, where there's going to be a delayed connection between the use of an edible and when you actually see it create the influence. Here's another complexity. I think it's, what does under the influence actually mean in a workplace setting, or what does it mean in general when you talk about marijuana? I don't think we have a good handle on what it means here in New Jersey yet. So we actually looked out to Illinois, because Illinois' statute actually has a little bit more robust way of defining it, which may be instructive to how we sort of interpret it here in New Jersey. So it doesn't need to include a positive drug test to show that somebody is under the influence, but employers have to be able to articulate symptoms, the kind of symptoms I mentioned on the prior slide, that lessen the employee's ability to perform or do the duties and tasks of the job. So if an employer can articulate some of these things, like erratic behavior, speech, change speech, physical dexterity issues, where they're not, where they lack their coordination, or they're acting in an irrational way, Those are the types of things that we as employers ought to factor into our policies about how we determine somebody that's under the influence, and how and under what circumstances we take action when we see these things in the workplace. So as an employer, if we can articulate and if a manager can articulate these items, that would give us the ability to take action against somebody who's under the influence in the workplace, even without a positive drug test. And I think, what makes it a little bit more complicated too is when you start to factor in the medical marijuana usage, like in this Rhode Island case that we've looked at. So what we're starting to see little by little around the country are cases in which people have sued their employers because they've been terminated for either refusing to submit to a drug test or because they showed a positive drug test. This Colpitts case in particular comes out of Rhode Island. Um, uh, Somebody who had Colpitts was an employee at WB Mason who actually had an on-the-job accident, and under the company's policy was subject to a drug test. When he was questioned by the supervisor and his branch manager, and told he had to go for a drug test and following the accident, he got agitated, which is one of the symptoms you would tend to see. But then he then disclosed for the first time that he had used medical marijuana and would probably test positive for marijuana if he was forced to test. Once he arrived at the test facility, he actually refused to be tested, though he agreed to an alcohol test, which came out negative. But because of this whole situation, his employment was terminated, and in particular, he was terminated because he violated company policy on the drug test. So, in this particular case, what's important to note is that the request was based on a reasonable suspicion because of his behavior. And the fact that the complicating factor here is that the employee did not tell his employer about the medical marijuana usage. So I couldn't tell you exactly how that factor plays into the ultimate decision. The unfortunate part of it that Colpitts was actually using for marijuana, not for PTSD, I believe related to some military service. So in this particular case, the court actually found against the employee and allowed the termination to continue, allowed the termination to stand. But the reason I bring up this case is it shows just the difficulty of sort of balancing all of these different factors. This particular employee failed to disclose the medical marijuana usage. He, based on what we read in the case, he appeared to have a good faith basis to use it. It was prescribed to him. It was for a legitimate condition, but failed to tell his employer, and thereby just prevented the employer from doing that balancing that I'm talking about. So what we might have had is some ability to sort of accommodate the usage, but because of the failure to disclose, the employer never had the chance to do it. And I think that his failure to disclose was probably not only based on the company policy, but also, based on reluctance of people who are using it, even for medical purposes, to tell their employers unless they absolutely have to. So this I think creates yet another level of complexity in terms of how you manage these cases in the workplace. When you talk about the New Jersey situation, this regulatory commission that I mentioned earlier, that again just started to meet next week, is going to establish standards for identifying impairment, but we just don't have those standards yet. But what we're looking at right now, or at least the current state of affairs, is that the scheme would require employers to engage what's known as a workplace impairment recognition expert, or a WIRE. So the WIRE, this person that is assigned this task, would be called to assess the worker's perceived impairment. So it's suggesting to me that you're going to have some third party that you'd call in response to a suspected case of marijuana usage among your employees, and get that person to make the assessment. What it's doing is sort of taking the issue out of the employers and out of the manager's hands, and putting it in the hands of a third party. Exactly how that's going to work out, though, and how it's going to be administered, nobody knows at the moment. But what we do know from the high level proposal is that if the WIRE concludes that the person is under the influence, and And if there's a drug test following the assessment, then the employer can take the adverse employment action. But again, what we're seeing is that it's taking a lot of the control of the employee out of the hands of the managers, which to me as an employment lawyer is pretty concerning for sure. Just out of these couple of discussions, here's some takeaways in my view. Number one is where you've got employees using medical marijuana use, I think you want to have a scenario in which you're going to encourage them to disclose it so that you as an employer, you as a manager are going to know who's using it, how they're using it, and be able to accommodate them where you can, but also manage the safety of their coworkers and manage the safety of your workplace. Having written procedures in place on how you deal with under the influence cases, I think is critical. Whether that policy would change to accommodate this new wire concept remains to be seen. But certainly having a guidebook in place to tell the managers how to deal with it is critical, in my opinion, for the reasons we talked about. If an employee consents to a voluntary test, assuming that's going to be appropriate, confirm in writing that they've consented to it, get a signature, so you've got that documentation. And then as with a lot of these issues, what we need to do is await more regulations from Trenton, because we're very much at the beginning stages of this, for sure. Let's talk about pre-employment testing for a moment. So the traditional approach and among virtually every client that we have that does pre-employment testing is to include THC in the test spectrum. As I mentioned before, the recruiting dilemma is that in many areas you're going to have a difficult time finding candidates. Especially in manufacturing environments in New Jersey, I think it's always a challenge to find good employee candidates. This makes it even that much harder if you've got a policy that tests for THC and on a pre-employment side, and scans out people who test positive. Keep in mind, by the way, that CBD oil may give a false positive because it may contain trace amounts of THC. So that's something to keep in mind as well. So even somebody who does show up positive may not be really using something that we're too concerned about. But where are we going in New Jersey is the question. I just wanted to point to what's happening in two places, New York City, right across the river, and Nevada, where it's illegal to test pre-employment for marijuana, except in those exceptions. Those exceptions are very similar in most cases to what we saw in the exemptions earlier. Also, where a collective bargaining agreement controls, and in some healthcare positions as well, on top of those. So what we're starting to see is legislative activity that makes it illegal to even think about testing for it. So, and again, unless you find yourself in one of these categories. I would tend to think that when we talk about people with commercial driver's licenses and construction, we're generally talking about safety sensitive positions, although we're not seeing too much discussion about that. Because in other words, there may be other positions that you'll look to see exemptions for in terms of pre-employment testing. So medical marijuana use is the other big silo I mentioned at the beginning. This is where a lot of the case law, certainly where the New Jersey case law has come up in the last year or so, just in terms of where this issue comes up. So we mentioned the Controlled Substances Act, which is the federal statute that criminalizes marijuana and the possession of it and distribution of it. So up until the last few years, states would cite to the federal preemption as a basis to uphold terminations based on marijuana use. What that basically means is the states would say that the issue has been regulated by the feds criminalized it, therefore we can't do it at the state level, and a termination based on marijuana use would stand as a matter of state law because the federal law controls. But in more recent case law, what we're seeing is that as courts cite to the Constitution, particularly the 10th Amendment, which says that powers that aren't delegated to the United States by the Constitution are reserved to the states. What does that mean? It means basically if the Constitution doesn't cover the issue and delegate it to the feds, that the states get to determine how they want to handle the issue, really. And so what that means is, even if the feds have criminalized it at the federal level, if it's not specifically called for in the Constitution and specifically preempted in the statute, that states are free to regulate it as they wish. Then we started to see at the Justice Department beginning in 2013 some softening on this issue. So, despite what the Controlled Substances Act said, uh, Deputy Attorney General Cole wrote a memo in 2013 that advised the U.S. attorneys around the country that they basically shouldn't waste their money and waste their resources to enforce the Controlled Substances Act against medical marijuana use at the time at the state level. So they were beginning to become aware that patients were being prescribed marijuana for a variety of uses, and despite the fact that it was illegal at the federal level, the feds didn't want to prosecute it anymore. When President Trump was elected in 2016, Attorney General Sessions, actually in 2018, a little bit after the election, but Attorney General Sessions rescinded that memo. Attorney General Barr came up with kind of a middle position after he was appointed. He adopted a softer approach to basically say that the Cole Memorandum would stand for the time being and left it up to individual U.S. attorneys to decide how they wanted to prosecute it in their states. And that gave them a little bit more flexibility, allowed the U.S. attorneys to sort of recognize the differences district to district. But in general, what we're seeing is that it's not really being prosecuted at the federal level when it comes to medical marijuana usage. Also in 2020 and later, actually 2020, maybe going back to about 2015, the Federal Appropriations Act actually prohibited the Justice Department from using federal funds to prevent states from implementing medical marijuana laws. So again, that was the next step, is that the Fed said don't use any federal money to prevent that from happening, which would mean don't prosecute people who are using medical marijuana. And there were a number of cases in Arizona and other places where medical marijuana users were terminated, and courts in their litigations found that usage should have been accommodated as a disability and considered in the termination process, and that they shouldn't have been terminated for the medical marijuana use. There's a couple of cases go the other direction for sure. So there is some variation state to state. But what we're starting to see is the beachhead was getting softened beginning in 2013 for sure. And there was a statute called the Veterans Medical Marijuana Safe Harbor Act that was introduced just this month actually, which allows, if it's passed, would allow veterans to use, possess, or transport medical marijuana. And that would be authorized by the Department of Veteran Affairs. So I think what we start to see again is this sort of evolution of the issue, where what was prohibited 100% beginning in the 70s, all of a sudden is, over time, is becoming more and more accepted. Specifically in New Jersey, what you're seeing is the Compassionate Usage Medical Marijuana Act, or CUMA. And there's a couple of cases that we'll talk about. One from last week, as I said earlier, Hager versus M&K Construction, and Wild versus Carriage Funeral Home, which give us some insight into what we're seeing at the state level. And I think you may have heard about these cases, but I think what they're doing is advancing this view of medical marijuana use as something that needs to be rebalanced in the workplace in New Jersey. So the Compassionate Use Act, it's now called, by the way, the J. Koenig Compassionate Use Medical Cannabis Act, but it was passed in 2010. It doesn't it doesn't alter any pre-existing employment rights or obligations, but it does prohibit the adverse employment actions based on registrant status, meaning if you've got the medical marijuana card, you can't be terminated just because you have that card. And it does not require the employer to be in violation of state law here too. So, and what it also provides is an exemption for medical reimbursement to government medical assistance programs and private health plans. Where the reason for that is that the plans were barred they were barred from reimbursing for the cost of medical marijuana usage until the Compassionate Use Act was passed. So the Compassionate Use Act doesn't prohibit drug tests, but workers can now provide explanations for what they're using it for, how they're using it, the conditions that you're using. And again, it's part of this disclosure that I mentioned earlier. Even without this statute, what we want to have in the workplace is employees advising their employers about the fact that they're using it, because they are protected from adverse employment actions uh, solely because they're using it as a registered medical patient. So what we want to encourage people to do is speak up, let their managers know that they're using, so that balancing that I mentioned earlier can occur. So the first case that we saw around this issue came late in 2020. Um, Wild versus Carriage Funeral Home. It was about an employee at the funeral home who used permitted medical marijuana as part of his cancer treatment. So he was involved in a car accident during the course of his work. Uh, he informed both his doctor and his employer that had been using medical marijuana outside of work, which I think is important. He wasn't using it during work hours, wasn't using it in the car or at the workplace. It was outside of work. Uh, so the doctor that treated him after the accident did not perform a drug test because he did not perceive that the plaintiff was impaired. But the plaintiff's employer later required him to submit to a drug test before he could come back to work. And by the way, if you know how drug tests are impacted by marijuana use, what you would typically find is that a user may test positive for up to 30 days after usage. So he already admitted the use, and it was almost a certainty that he would test positive. So the employer required him to submit to the test, and he refused. Or actually, he either refused. It's not really relevant to the case. He either refused or showed positive, but in any event was terminated. And he sued his employer for improper termination. And what we know from this case is that that number one, employers need to accommodate medical uses outside the workplace, or else be subject to discrimination claims under the New Jersey law against discrimination for failure to accommodate. All right, so that is a big change for employers in terms of this rebalancing we talk about. Now, what's also interesting, in my opinion, is the mere knowledge by an employer about the lawful medical marijuana use would trigger a duty to engage in an interactive process, just as you would in the process to accommodate a disability. So the fact that the employer knew about the usage shouldn't have resulted in a termination in this case, but rather should have triggered that interactive process to see if it could be accommodated. Again, because the employee wasn't necessarily impaired by the usage of the medical marijuana off hours, and could have been accommodated, at least theoretically here. And the employee does not have to request the accommodation. I think the best practice, though, of course, is to have this interactive dialogue. But the employee did not have to formally make the request. Now, CUMA, on the other hand, does not impose a duty to accommodate workplace use. So in this particular case, Wild never used it in the workplace, and the court made sure to say that it would not require any accommodation for work during use during work hours. So that is important as well. Not really relevant to this particular case because he hadn't used it, but nevertheless, it gives us some instruction about where the limit is in terms of the interactive process. No accommodation to use during work hours. This is an interesting case from last week, actually, too. This is another medical marijuana case, and the court, this is the New Jersey Supreme Court, spent a lot of time sort of going back through the history that we've covered today, and made some interesting findings. Number one, found against federal preemption. So specifically found the Controlled Substances Act does not preempt the state's, in particular New Jersey's, ability to legislate at the state level. This is where again, we've seen this momentum or this evolution process. Medical marijuana and the cost of it are covered by the workers' compensation scheme. That was the issue in this particular case. Is Hager was injured on the job in the course of doing construction work, and one of his physicians prescribed medical marijuana use not only for the pain he suffered, but also because of the secondary problem of some reliance on opioids and some addiction to opioids. So, which apparently worked in his case. So the first issue was whether the health plan would have to cover it, and the answer was yes. That is the workers' compensation health plan. Um, and the court also acknowledged that marijuana might be considered reasonably necessary treatment under the Workers' Compensation Act. Again, another development that we hadn't seen before. Um, Also found that uh, a distinction between this intent to distribute versus a valid prescription, finding that the workers' compensation insurer would cover or should cover the cost of it without being subject to some charge for intent to distribute or some conspiracy to violate the federal law. And found in that regard that the federal statute and the Compassionate Use Act don't collide; they don't conflict with one another. I also, just as a practitioner, I say for myself that I find it interesting that the court would make that determination about reasonable necessity, despite the lack of FDA approval, despite the lack of testing, a specific finding of efficacy. In this particular case, what we see though um, the is the anecdotal evidence anyway that the treatment was effective. Um, for this particular employee. So it appeared to be effective, but as a general rule, we don't have any sort of scientific studies or FDA approval of any process or any use that we saw in this particular case. So what the court did leave open though is this idea that whether marijuana would be considered for effective for a certain condition is subject to competent medical testimony. So whose burden of proof it is was not clear. But in order to justify the obligation to pay, what you might have is maybe a disagreement among experts about whether it's effective. I get the impression though that as long as a medical provider has prescribed it, there's almost a sort of a prima facie view that it is effective, and it's going to be a little bit difficult to argue that it's not. Now, the court also cautioned here that legislative action in the future may change the rule. So we need to stay tuned for those developments. But sitting here today, this is the rule. So if you've got a workers' compensation claim and medical marijuana has been prescribed, it's going to get covered as reasonably necessary, unless there's some clear indicator that it's not valid for some reason. What do you need to think about as an employer? Again, I've said it a number of times before, and I'll say it again, having a policy about it, memorializing this interactive process that we've talked about, talking about medical marijuana in the same way that you talk about disabilities and handling it a very similar way, I think should be part of your policy. Training managers to recognize impairment, even among medical users, is important as well. We got to stay on top of this, I think, because the law is anything but established. It's going to continue to evolve and change, and the requirements are going to change as well. So we need to keep our eyes on that for sure. Usage during the workday, I put a question mark there because I don't personally know whether usage during the workday, even off premises, is going to create, in all cases, a situation that can't be managed. Whether somebody would be under the influence even with a very small quantity of usage. So that to me is a question worth answering for sure. What forms of cannabis people can use, or I think we're going to continue to see new ones, but recognizing that there's edibles versus smoke, and what does that mean in terms of your policy? Defining impairment, amount of time before the shifts in which people can use or can't use cannabis, and then defining what safety sensitive positions is. The amount of time before the shifts issue is really whether you want to have a buffer of time between the last time somebody used the cannabis product and when they start their shift. In that particular issue, you ought to think about on-call employees as well. If you're going to put somebody on call, in my opinion, your policy rather ought to be that they're not permitted to use marijuana within a certain amount of time before the on-call, as well as during the on-call period. So if you're going to allow it at all, make sure that you account for those factors as well. And then, this is a bit of a cultural issue maybe, but do we and should we differentiate between safety sensitive positions and office workers? Folks that don't touch machinery or vehicles, don't drive a fleet vehicle, for example, should they be treated in a different way from folks that do? Certainly, the safety component kind of suggests that we ought to, but then when you start to differentiate among classes of employees, you may impact your culture in a certain way, or you may impact your ability to recruit for certain positions. All, as I said before, there's no one answer. It's going to depend a little bit on your particular workplace, but I think those are things that you ought to consider as you develop your policies. And now, uh, as we go through the next couple of slides, I'll look at your questions and we'll get to answer those at the end. But I get to take a breath for a moment and pass the baton to my friend Steve McMaster, who's going to talk about the Recover ultra-sensitive rapid testing platform that I think it's obvious why it's interesting, but just to make sure we sort of share the thought. I talked a lot about the issue of how do you identify whether somebody's impaired and how do you measure that. This particular technology, I think, gives us another option for doing that. In addition to having the training that I mentioned to be able to recognize it, this technology may give you another bullet in your holster. So with that, I'll pass the baton to Steve.
Thank you, Chris, and good afternoon, everyone. Chris, the presentation provided some excellent insights, and I'm really glad that you put this together, and I'm honored to be a part of your panel here. To give some background, I'm the CFO and General Counsel of a portfolio of companies engaged in construction and manufacturing, and my previous employer was a unionized heavy civil infrastructure firm. So with that in mind, I've been following the legal cannabis industry closely, as it is of great importance to me in the industries in which I've operated that this topic be handled appropriately and within the letter of the laws in this evolving landscape. You saw through Chris's slides that construction was mentioned many times, manufacturing as well. These are high-risk industries with heavy machinery, and worker safety is paramount. So to give some background on Recover, I met the founders by way of my work with Princeton University's Keller Center for Innovation. And after I met them and they discussed their product with me, it immediately piqued my interest. Can we go to the next slide? So this is the model of what the device will look like when it comes to market. It's expected to come to market in July of this year. So it's a rapid testing platform. It uses saliva, but in many ways you could think of it as a breathalyzer for THC. It's what we need because the current methods of testing are ineffective for real-time detection of THC. Urine tests can test from use for weeks prior to the actual test. And blood tests, while they can certainly show whether it's currently in someone's system, they're rather invasive, and you run into some constitutional issues as well with regard to the Fourth Amendment, whether it's appropriate to actually draw blood from someone's body. Chris, can we go to the next slide? Okay. So as Chris described in his presentation, legal cannabis presents a unique dilemma for safety in the workplace, increase in workplace accidents, injuries, higher absenteeism, and being able to test people when there is a workplace incident on the spot, as you could with alcohol, that will be a game changer. I've spoken to a number of different people in the insurance industry, and as a loss mitigation technique, real-time testing will be huge. It's absolutely necessary, and that's where this industry is headed. And it will also likely help employers who have this sort of device on hand reduce their premiums. It'll make them more attractive as well when they go to market and seek insurance with different carriers. And then beyond that, the way I see it, the existence of such a device is likely to reduce the number of incidents, because people knowing that they can be tested for it, that they can't just cover up their use with some Visine, that makes it far less likely that someone would take the risk of using cannabis during work hours or being under the influence while on the clock. And another thing that's very important to me in this regard is that we don't want people to find their jobs in jeopardy because they use cannabis responsibly. We're talking about someone who could use responsibly the week prior, and if they fail a urine test, then they could lose their job even though they haven't done anything wrong. So with that in mind, can we go to the next slide? This is how these saliva platform works. You take a saliva collection in this syringe, then they insert the syringe into the reader, and then the reader gives rapid results within a few minutes, about 5 minutes. So being able to have this sort of solution will, it'll really change everything. And that's where we're headed with this. So if we can go to the next slide. You see that it's 25 times more sensitive and 5 times faster than other rapid result tests that are on the market now. And they can actually detect it to 1 nanogram per milliliter. That actually turned out to be a little too sensitive. They found that the sweet spot is 5 nanograms per milliliter. So the technology is there. And having that will just greatly change everything as cannabis continues to become legal in different states and as it's regulated throughout different industries. Can we go to the next slide? So as they were bringing the THC test to market, the thesis was always that it would be a multi-use device, such that when the COVID pandemic hit last year, one of the founders is a medical doctor by training. They decided to test a thesis that it could test for COVID as well. And their thesis was proven. So it can test for COVID before symptoms start at 10 picograms, as you can see on this chart here. Being able to test for COVID and THC with the same device, in terms of workplace safety and HR, everything else we've been discussing here, it really puts employers in such a better position to just treat their employees with the care that they require and to make sure that everyone is as safe as possible in this rapidly changing world. And can we go to the next slide? This is the advisory board of Recover. As you can see, it's the former CEO of Quest Diagnostics, former CEO of Spirit Airlines, and a former co-head of Goldman Sachs in their technology banking, and also current board chair of the New Jersey Economic Development Association. So it's been going very well. And from my seat in the construction and manufacturing industry, I just see that something like this, it needs to be out there. People need to know about it and need to know that it's going to be available and that we will be safer as a result of these improvements in technology and the way in which we're addressing this rapidly changing world.
So Steve, one of the benefits of the sensitivity of the test is basically you can distinguish between, or you can determine when the cannabis use occurred, essentially.
Yes.
Which allows you to use it responsibly off hours, but not basically right before work and to be under the influence during work. Is that a good way to summarize it?
Definitely, because the use of saliva specifically, the concentration within the saliva decreases very rapidly. So based on the readout, it can, or the actual level within the saliva, they can determine how long it has been since use and the level at which it's currently within the patient's system. Right. So it tests for acute intoxication.
And what would, is there sort of a standard limit or a standard test result that would tell you that whether somebody's under the influence, or does it depend on the individual, based on size and age and that sort of thing?
Well, there is no legal baseline yet. We have the legal baseline for alcohol, which is 0.08%. And until there is a legally determined baseline for what would consider cannabis or THC intoxication, this is focused mainly on private employers that need to determine whether someone's under the influence during a workplace accident, or in the case of construction and manufacturing, also common carriers such as airlines, where they can have a zero tolerance policy altogether, as you covered, Chris. Just whether someone has it in their system at all while they're on the clock. So they actually have letters of intent for purchase from several different state police departments, but until it is legislatively defined what that level of nanograms in the patient's system are, then it wouldn't be suited for like roadside tests.
This is great. This is sounds like an excellent advancement that's going to enable us to do more of that balancing I talked about for sure.
It will, and it will really help the regulators determine how they're going to treat the use of cannabis in many ways in which they regulate the use of alcohol.
One of the folks on the call is asking, what's the cost of the device, Steve?
Right now, they're pricing it at $500 per device, and then the test strips are, you only need one device, or I mean, if you have like several different job sites, you want one at each job site, but it's the test strips that are interchangeable, and they are $5 to $7 depending on the test that you're seeking.
Got it. Great. If any other folks have questions about the device, feel free to post them up in the Q&A. Steve, I really appreciate you joining us today.
I appreciate you for hosting, Chris. This is some really important information. I'm glad that you're getting it out there for everybody.
Thanks.
I appreciate everyone who attended as well. So I see a question on the chat from Aline Kostin. What is the accuracy of the test on the rapid test? So it is accurate to 1 nanogram per milliliter, which is more accurate than any other competing test that's being tested these days and going through clinical trials.
Great. Yeah, as you said before, it was almost too sensitive.
Yes.
Great. Well, great. So that'll cover the test. I'd like to open up the floor for a few more questions. We've got a couple of good questions on the chat right now. One of our folks is asking, should we treat cannabis use in the same way we treat alcohol in the workplace? I think the answer is yes, in my opinion. That's why I was mentioning earlier about differentiating between off-hours use versus workplace use. It would be virtually impossible, in my opinion, to manage a workplace effectively if you had people using it during the workday. What we've talked about with Steve's device in particular is the ability to distinguish between off-hours use or responsible use, legal use versus use in the workplace. So I would agree with that. Let's prevent use in the workplace for sure, and then figure out how we balance it after that. Another question is, by asking employees to disclose medical usage and the reasons for its use, are we getting close to a HIPAA issue? I think whether or not an employer is going to be subject to HIPAA really depends on the employer. But certainly an employer who collects health information is going to be subject to privacy requirements at the very least, whether or not they're subject to HIPAA. So you need to make sure that you manage that information effectively, that you store it separately from the personnel file, among other things, and you prevent its unintended disclosure for sure. You don't necessarily need to find out why somebody's using the medical marijuana, or you don't necessarily need to know the reason for which it was prescribed. In my opinion, the only thing you need to worry about is whether somebody's using it and when. And then you go through that interactive process to do the accommodation. So you would want to limit your questions to yes or no, whether somebody's using it. And if they want to voluntarily disclose the reason, that's up to them for sure. But managing the fact that somebody used it and when they used it is really the important issue. Well, your point's a good one. We got to make sure that we preserve the confidentiality of the information that you collect. Well, that looks like the end of the questions. Somebody also asked whether we would share the slide deck. I'm happy to share the slide deck. If you send me an email, I'll be happy to send it out to you. And again, just another way to continue the dialogue that we started today. But echoing what Steve said a moment ago, I want to thank everyone for joining us today. This kind of discussion is really an important one, so that we can share information and learn from each other's individual situations, and also share the new perspectives, find out different ways to rebalance our workforces, as well as to accommodate all these new changes in how we're going to manage employees. So I'd love to keep the conversation going and continue that dialogue. And we'll reach out to you in the coming days to find some opportunities to do that. If you have any questions that we weren't able to answer today, or things you think about after the presentation, feel free to send me a note as well, or give me a call, and we'll have that conversation. So again, thank you all to everyone who came today, and I'll look forward to staying in touch. Have a good day.
Thank you, Chris.